Hello Year 12s and welcome to this video on the Victorian Civil and Administrative Tribunal, in which we look at the purposes and appropriateness of the Victorian Civil and Administrative Tribunal as a dispute resolution body. There are 4 things that you need to do while you're watching this video. The first thing is to take the very best Cornell notes that you can. The second thing is to use the pause and rewind functions. Use the pause function if you need to stop this video to take notes. Use the rewind function if you need to go back over any information contained in this video. The third thing that you need to do is to have your vocabulary sheets open in front of you so that you can write into your vocabulary sheets the meanings of key terms or of any other words that you may be unfamiliar with. And the fourth thing that you need to do is have your summary books open in front of you. As we go through this video, I will give you some guidance as to what you should include in your summary books. I have separately provided you with a table that summarizes much of the important information that is contained in this video. You should supplement this table with any additional information from this video that you think is useful, and then include this table in your summary books. Once you've finished watching this video, make sure that you read the pages from the textbook referred to on this slide. And if you find any additional information from that reading that you think is useful, then include that information in your Cornell notes. On this slide, I have set out the 2 learning intentions for this video. Make sure that you write these learning intentions in your Cornell notes. The first learning intention is that you should be able to describe the purposes of the Victorian Civil and Administrative Tribunal in resolving civil disputes. The second learning intention is that you should be able to discuss the appropriateness of the Victorian Civil and Administrative Tribunal in resolving civil disputes. In class, we'll also be doing a number of learning activities which will help you to achieve these learning intentions. In this video, we are focusing on one type of dispute resolution body that resolves civil disputes. This is the Victorian Civil and Administrative Tribunal. However, we'll also be comparing the appropriateness of the Victorian Civil and Administrative Tribunal in resolving disputes with the appropriateness of 2 other dispute resolution bodies in resolving disputes. That is, Consumer Affairs Victoria, which we've looked at in a previous video, and the courts. Remember that dispute resolution bodies are different from dispute resolution methods. Dispute resolution methods are ways of resolving civil disputes, and different dispute resolution bodies use different dispute resolution methods. The Victorian Civil and Administrative Tribunal is a dispute resolution body that uses mediation, conciliation, and final hearings as its dispute resolution methods for resolving civil disputes. You must read any SAC or exam question carefully to see whether it is referring to a dispute resolution method or a dispute resolution body. This is because it makes no sense to compare dispute resolution methods with dispute resolution bodies. It only makes sense to compare the different dispute resolution methods amongst themselves or the different dispute resolution bodies amongst themselves. So, for example, you would not compare mediation with the Victorian Civil and Administrative Tribunal, but you could compare mediation with another dispute resolution method like arbitration. Or you could compare the Victorian Civil and Administrative Tribunal with another dispute resolution body such as Consumer Affairs Victoria or the courts. In the previous video, in which we looked at some important background information about the Victorian Civil and Administrative Tribunal, I explained to you that the Victorian Civil and Administrative Tribunal is a tribunal established under the Victorian Civil and Administrative Tribunal Act of 1998 Victoria that consists of a number of specialist divisions which have jurisdiction to resolve different types of civil disputes in Victoria. And I also explained that the Victorian Civil and Administrative Tribunal uses 3 dispute resolution methods to resolve civil disputes, namely mediation, conciliation, and final hearing. Note that the one dispute resolution method that the Victorian Civil and Administrative Tribunal does not use is arbitration. In an exam or SAC question, if you're referring to the Victorian Civil and Administrative Tribunal, you can abbreviate it to VCAT, that is VCAT, providing that in your answer, where you first refer to the Victorian Civil and Administrative Tribunal, you write its name out in full, and then include the letters VCA and T in brackets after that name. In the rest of this video, I will be referring to the Victorian Civil and Administrative Tribunal as VCAT. Our first learning intention is that you should be able to describe the purposes of VCAT in resolving civil disputes. The purpose of VCAT in resolving civil disputes is to provide independent, low-cost, accessible, efficient, and expert dispute resolution services to assist in the resolution of civil disputes. Make sure that you write this purpose down in your summary books. As you can see, there are 5 purposes of VCAT in providing dispute resolution services. The following slides look at each of these purposes in turn and explain how VCAT achieves them. In your summary books, please draw up a table like the table on this slide. You can see that I've listed the 5 purposes of VCAT in providing dispute resolution services in the left-hand column. You'll need to describe how the relevant purpose is achieved in the middle column, together with some examples that illustrate your description in the right-hand column. The first purpose of VCAT is to provide independent dispute resolution services. VCAT members are independent, which means that they're able to hear and resolve disputes impartially, that is, without favouring any party. This is critical to ensuring that each party is given a reasonable opportunity to explain their case, that the parties are fairly treated, and that any resolution of the dispute between the parties is also fair. In this way, VCAT is like Consumer Affairs Victoria and the courts, which are also independent dispute resolution bodies. The second purpose of VCAT is to provide low-cost dispute resolution services. Where a party brings a dispute to VCAT, VCAT will generally charge that party an application fee, also known as a filing fee, which is a fee for applying to VCAT to deal with the dispute. In addition, VCAT will generally charge the party a daily hearing fee, which is a fee for each day that VCAT spends hearing the dispute. The amount of these fees depends on the type of party that is applying to VCAT to have VCAT deal with the dispute and the nature of the dispute. As far as the type of party is concerned, VCAT charges different application and daily hearing fees depending on whether the party is a person who has a healthcare card, an individual who does not have a healthcare card, or a business. Healthcare card holders are charged the lowest application and daily hearing fees, that is, VCAT's concession fees. Other individuals, that is, people who are not healthcare card holders, as well as not-for-profit organisations such as charities and businesses with a turnover, that is revenue, of less than $200,000 per annum, pay higher application and daily hearing fees, that is, VCAT's standard fees. and businesses with a turnover, that is revenue, of more than $200,000 per annum pay the highest application and daily hearing fees, that is VCAT's corporate fees. In this way, VCAT's application and daily hearing fees are intended to promote fairness by charging parties according to their ability to pay. In addition, application and daily hearing fees are lower for smaller disputes than for larger disputes. For example, there's no application fee for healthcare card holders where the dispute is a residential tenancies dispute. These disputes tend to be small because they relate to matters such as repairs and rent. Likewise, the first day of a hearing for small claims relating to goods and services, that is, where the claim is for up to $100,000, is free. Because these claims are only likely to involve a hearing for no more than one day, this effectively means that there is no daily hearing fee for these kinds of disputes. So you can see that VCAT is quite a low-cost option for smaller disputes in the sense that its application and daily hearing fees for smaller disputes are relatively low. On the other hand, VCAT's application and daily hearing fees for larger disputes, which are likely to involve large businesses and are likely to take a number of days to hear, are significantly higher and are, in many cases, comparable to the application and daily hearing fees that the courts charge. Apart from application and daily hearing fees, a major cost for parties in resolving civil disputes is the cost of paying lawyers to represent them. In this regard, VCAT's procedures are intended to enable the parties to represent themselves without a lawyer because they are user-friendly, that is, they are easy to understand. In particular, the rules of evidence and procedure that apply in court hearings do not apply in VCAT final hearings. The fact that the rules of evidence and procedure apply in court hearings is one of the main reasons why parties need a lawyer to represent them in court hearings. The rules of evidence and procedure are very complicated and technical, and only lawyers are able to properly understand them. So, by avoiding the need for lawyers, that is, by enabling parties to more easily represent themselves, VCAT is also able to resolve disputes for a lower cost than if the parties went to court. Parties are more likely to represent themselves in small and simple disputes because, where a dispute is small and simple, the parties will not want to spend much money in resolving that dispute. Having said this, the parties in a dispute that is being resolved at a VCAT final hearing will still often use lawyers where the dispute is large and complex. This is because lawyers are experts at arguing cases, which is a very important skill to have where the dispute is a complex one. In addition, because the VCAT member at a VCAT hearing will resolve the dispute by making a decision that is binding on the parties will often use lawyers because they'll want to ensure that their best case is put forward. If it's not, then there is a risk that the decision that is made will be unfavourable to them, but that they'll still be required to comply with that decision unless they're able to have it reversed by appealing it to the Supreme Court. Where the case is large, that is, where the case involves lots of money, a party will be very keen to make sure that their case is presented in the best way possible. In summary, VCAT, like Consumer Affairs Victoria, is a low-cost dispute resolution body for small and simple disputes because its application and daily hearing fees are low for small and simple disputes and because its procedures facilitate parties representing themselves, which means that the parties can save on the costs of lawyers. However, where the dispute is large and complex, VCAT's application and daily hearing fees are comparable to the courts, and the parties will typically be represented by lawyers. This means that, for large and complex disputes, the costs for a party of having their dispute resolved at a final hearing by VCAT or a court are similar. The third purpose of VCAT is to provide accessible dispute resolution services, that is, to make it easier for parties to bring their case and enforce their rights. We've just looked at a major way that VCAT does this. VCAT's procedures are intended to enable parties to represent themselves without a lawyer because they are user-friendly, that is, they're easy to understand. In particular, the technical and complex rules of evidence and procedure that apply in court hearings, and which can only really be understood by lawyers, do not apply in VCAT hearings. This improves access because a party can argue their own case. It also improves access because the party doesn't have to pay for a lawyer, and legal costs can be a significant barrier to a party bringing their case. As I've said, parties are more likely to represent themselves in small and simple disputes. Finally, VCAT improves access through conducting hearings by telephone or video as well as in person. This makes VCAT particularly accessible for small and simple disputes where a party might not otherwise be willing to bring their claim because of the inconvenience of attending a VCAT hearing in person. However, as I've also already said, where the dispute is large and complex, then the parties will often use lawyers at a VCAT final hearing because lawyers are experts at arguing complex cases and because the parties will want to ensure that their best case is put forward as the decision at a VCAT final hearing is binding on the parties. There are a number of other ways in which VCAT provides access to parties to a dispute. First, VCAT has a number of venues in Melbourne as well as venues in some regional centres such as Bendigo. This makes it fairly easy for parties to access VCAT to deal with their dispute. Second, VCAT enables parties to lodge their documents online rather than having to lodge paper copies. Again, this is beneficial for parties who might find it difficult to physically take paper copies of documents to a VCAT venue. And finally, a party who is a Koori person can be assisted to understand VCAT procedures by the VCAT Koori Engagement Officer. The fourth purpose of VCAT is to provide efficient dispute resolution services. That is, VCAT tries to resolve disputes as quickly as possible. In particular, up until recently, VCAT has been very quick at resolving small and simple disputes. For example, the Residential Tenancies List, which deals with disputes between landlords and tenants in relation to rented houses, flats and other accommodation, is the busiest list in VCAT. However, on average, there's only a 4-week wait between the time when a party applies to VCAT to deal with this kind of dispute and when VCAT actually hears the case. Having said this, the COVID pandemic lockdowns have resulted in significant backlogs in other lists, even for small and simple disputes. For example, the second busiest list in VCAT is the Civil Claims List, which deals with a range of disputes, including disputes between consumers and suppliers over defective goods. The average time between when a party applies to VCAT to deal with such a dispute and when VCAT actually hears the case is now 52 weeks. Nonetheless, when a small and simple dispute is heard by VCAT, VCAT is very efficient at dealing with it. Most hearings of small and simple disputes take less than 1 day. It is a different story for large and complex disputes. There are significant delays in VCAT dealing with large and complex disputes. For example, the average time between when a party applies to VCAT's Planning and Environment Division to deal with a dispute and when VCAT actually hears the case is 25 weeks. In addition, VCAT can take nearly as long as the courts to hear and decide large and complex disputes. In summary, VCAT, like Consumer Affairs Victoria, is generally a quick dispute resolution body for small and simple disputes. However, where the dispute is large and complex, the time it takes VCAT to hear and decide the case is nearly as long as it would take the courts, with their backlogs and pretrial procedures such as the exchange of documents and other evidence to hear and decide the case. The fifth and final purpose of VCAT is to provide expert dispute resolution services. As you'll recall from the previous video, the VCAT President and Vice Presidents are judges, but the other members of VCAT have a range of specialised skills and qualifications, which means that they are experts in the different types of disputes that VCAT deals with. For example, VCAT members who are engineers or architects will be experts at dealing with disputes about building works. VCAT members who are medical practitioners will be experts at dealing with disputes about whether a doctor or nurse has been treated appropriately in disciplinary proceedings, and so on. This expertise means that VCAT members will have a thorough understanding of the matters that are in dispute, and so they will be in a good position to assist the parties at a conciliation or to decide the dispute at a final hearing. In this respect, VCAT and Consumer Affairs Victoria are similar, as both of these dispute resolution bodies are subject matter experts. And this is also where VCAT differs from the courts. Judges and magistrates are legal experts who are experienced in conducting hearings, but they're not subject matter experts. So, where a judge or magistrate has to decide a more technical dispute, the parties have to educate the judge or magistrate about that technical dispute through providing expert evidence. Our second learning intention requires you to be able to discuss the appropriateness of VCAT in resolving civil disputes. In discussing whether VCAT is an appropriate dispute resolution body for resolving a particular civil dispute, there are two factors that you need to consider. In summary, VCAT will be an appropriate body for resolving a civil dispute if, first, the dispute is within VCAT's jurisdiction, and second, there is no better way to resolve the dispute. We'll look at these two factors in more detail in a moment. On this slide, I've set out a table that you need to include in your summary books. This table sets out each of the factors I've just outlined in the left-hand column. You will then need to describe the relevance of each of these factors in more detail in the right-hand column. Please make sure that you fill out this table as we work our way through these slides. The first factor that you need to consider in deciding whether VCAT is an appropriate dispute resolution body to resolve a particular civil dispute is whether that civil dispute is within the jurisdiction of VCAT, that is, whether VCAT has the power to deal with that dispute. As you know from the previous video on VCAT, the jurisdiction of VCAT is set out in a number of Victorian statutes, and so VCAT can't resolve a dispute unless jurisdiction to do that has been given to VCAT by one of those statutes. On this slide, I've listed some of the main types of civil disputes that VCAT does have jurisdiction to deal with. These include consumer disputes, as where a consumer has a dispute with a supplier over faulty goods; discrimination or equal opportunity disputes, as where an employee claims they've been discriminated against by an employer because of their sexual orientation; disputes between landlords and tenants, where the tenant lives in the rented premises. These are residential tenancy disputes. Disputes between landlords and tenants, where the tenant rents a shop from the landlord. These are retail tenancy disputes. Disputes over the construction or renovation of houses. These are domestic building disputes. Planning disputes, where a local council grants or refuses to grant a permit to allow a person to build or demolish something. And appeals against regulatory decisions, such as the valuation of land by a local council for rating purposes, the licensing of a taxi driver, or disciplinary action taken against a lawyer. However, while VCAT's jurisdiction is broad, there are some disputes that VCAT does not have jurisdiction to deal with. I've listed the main examples on this slide. Obviously, if VCAT does not have the jurisdiction to deal with a particular dispute, then it can't be an appropriate body to resolve that dispute. VCAT does not have jurisdiction to deal with general negligence claims, defamation claims, disputes between employers and employees, that is, industrial relations type disputes, disputes between neighbours, disputes between tenants, or disputes between drivers in a car accident. These kinds of disputes can only be dealt with by a court or perhaps by another body such as the Fair Work Commission. In addition, VCAT can't deal with class actions. Only the Trial Division of the Supreme Court can deal with class actions. This leads me to the second of the golden rules that you should apply in determining whether Consumer Affairs Victoria, VCAT, or the courts are the most appropriate dispute resolution body for resolving a particular civil dispute. We looked at the first golden rule that applies to Consumer Affairs Victoria in a previous video, and at the end of this video we'll look at the third golden rule that applies to the courts. The golden rule that applies to VCAT is that providing the dispute is within the jurisdiction of VCAT, VCAT will be the most appropriate dispute resolution body for that dispute where, first, the dispute is small and simple but is not within the jurisdiction of Consumer Affairs Victoria, or, second, the dispute is small and simple but the parties are unlikely to be able to resolve the dispute by agreement, or, third, the dispute is large and complex and the parties want a subject matter expert to decide the dispute. Let's unpack this golden rule. The threshold point is that VCAT will only be an appropriate dispute resolution body for a dispute if VCAT has jurisdiction to deal with that dispute. If VCAT does not have jurisdiction to deal with the dispute, VCAT cannot possibly be an appropriate body to deal with that dispute because it has no power to deal with that dispute. This brings us to the first limb of the second golden rule. This is that, assuming that VCAT has jurisdiction to deal with the dispute, then VCAT will be the most appropriate body to deal with the dispute where the dispute is small and simple but is not within the jurisdiction of Consumer Affairs Victoria. Why is this? Well, where a dispute is small, the parties will not want to spend much money and time resolving the dispute. The advantages of VCAT in this regard are that VCAT is low cost for small disputes. This is for two reasons. First, VCAT's application and daily hearing fees are low for small and simple disputes. For example, there's no application fee for healthcare card holders where the dispute is a residential tenancies dispute. And the first day of a hearing for small claims relating to goods and services, that is, where the claim is for up to $100,000, is free. Second, because VCAT's procedures facilitate parties representing themselves, parties can save on the cost of lawyers. Another advantage of VCAT is that it is quick for small disputes. For example, on average, there's only a 4-week wait between the time when a party applies to VCAT to deal with a residential tenancies dispute and when VCAT actually hears the case. Having said this, the COVID pandemic lockdowns have resulted in significant backlogs for other types of disputes, even where they are small. For example, the average time between when a party applies to VCAT to deal with a dispute between a consumer and a supplier over goods and services and when VCAT actually hears the case is currently 52 weeks. However, when a small and simple dispute is heard by VCAT, VCAT is very efficient at dealing with it. Most hearings of small and simple disputes take less than 1 day. In addition, the fact that disputes can be dealt with by telephone or video as well as in person minimises the time that the parties need to spend in participating in the dispute resolution process. For example, they don't have to spend time travelling to a VCAT venue for an in-person hearing. And the fact that VCAT has a number of venues in Melbourne as well as venues in some regional centres also reduces the time that parties need to spend travelling to a VCAT venue where they do have an in-person hearing. Now, as we've already seen, Consumer Affairs Victoria is also an appropriate dispute resolution body for small and simple disputes because, like VCAT, it is low cost and quick for small and simple disputes. Where a dispute is small and simple, one reason VCAT might be a more appropriate body than Consumer Affairs Victoria to resolve that dispute is if the dispute is within the jurisdiction of VCAT but is not within the jurisdiction of Consumer Affairs Victoria. This is because, in such a case, only VCAT and not Consumer Affairs Victoria will have the power to deal with the dispute. This brings us to the second limb of the second golden rule. This is that, assuming that VCAT has jurisdiction to deal with the dispute, then VCAT will be the most appropriate body to deal with the dispute where the dispute is small and simple, but the parties are unlikely to be able to resolve the dispute by agreement. Why is this? Well, as we've seen, both Consumer Affairs Victoria and VCAT are appropriate dispute resolution bodies for small and simple disputes because they are both low cost and quick for small and simple disputes. It is generally preferable for the parties to resolve their dispute by agreement rather than to have a decision imposed upon them by a third party. This is because, to reach an agreement, both parties will need to compromise, meaning that there is no clear-cut winner and no clear-cut loser. Consequently, both parties are more likely to be satisfied with the outcome. This is why our first golden rule says that Consumer Affairs Victoria will be the most appropriate dispute resolution body for a particular dispute where, among other things, the parties are willing to compromise. However, if the parties are unlikely to be able to resolve their dispute by agreement, then Consumer Affairs Victoria will not be an appropriate dispute resolution body because its dispute resolution method is conciliation, and so Consumer Affairs Victoria cannot resolve the dispute where the parties are unable to agree. Consumer Affairs Victoria cannot resolve the dispute by making a binding decision for the parties. In these circumstances, VCAT will be the most appropriate dispute resolution body because, when it uses its dispute resolution method of a final hearing, it can make a binding decision that resolves the dispute. In such a case, the agreement of the parties is not necessary for the dispute to be resolved. Now, let's consider the case of large and complex disputes. In a previous video, I explained that Consumer Affairs Victoria will not be the most appropriate body for resolving large and more complex disputes because, where a dispute is large and complex, it is less likely that the parties will be able to agree a resolution to their dispute, but Consumer Affairs Victoria cannot make a binding decision to resolve that dispute. And the parties to a large and complex dispute will often need structured procedures to enable them to conduct their dispute more efficiently. But Consumer Affairs Victoria's procedures are less formal and so do not provide this structure. The position with VCAT is very different. In this regard, it's very important to remember that VCAT doesn't just deal with small and simple disputes. On the contrary, it also deals with large and complex disputes. This is an important point that students often get wrong. This brings us to the third limb of the second golden rule. This is that, assuming that VCAT has jurisdiction to deal with the dispute, then VCAT will be the most appropriate body to deal with the dispute where the dispute is large and complex and the parties want a subject matter expert to decide the dispute. As I've said previously, apart from the VCAT president and vice presidents who are judges, the other members of VCAT have a range of specialised skills and qualifications, which means that they are experts in the different types of disputes that VCAT deals with. This expertise means that VCAT members will have a thorough understanding of the matters that are in dispute, and so they will be in a good position to assist the parties at a conciliation or to decide the dispute at a final hearing. This is different from where a dispute is dealt with by the courts, While judges and magistrates are legal experts who are experienced in conducting hearings, they are not subject matter experts. So far, we've focused on the appropriateness of Consumer Affairs Victoria as a dispute resolution body in a previous video, and the appropriateness of VCAT as a dispute resolution body in this video. In doing so, I have sometimes compared these dispute resolution bodies with our third type of dispute resolution body, that is, the courts. So it's time to state our third golden rule, which is that a court will be the most appropriate dispute resolution body to resolve a dispute where the dispute is large and complex, the parties prefer the formal structure of court proceedings, and the parties want a judge to decide the dispute because the dispute involves complicated legal issues and because the judge is an expert at conducting lengthy trials. Let's unpack this golden rule. First, the courts will generally not be appropriate dispute resolution bodies where the dispute is small and simple. This is because where a dispute is small and simple, the parties will not want to spend much money and time resolving the dispute. However, the courts are very costly. They have higher filing and daily hearing fees for smaller disputes than VCAT. And most significantly, the parties need to use lawyers. This is because lawyers are experts in the technical and complex rules of evidence and procedure that apply to court proceedings. The courts are also relatively slow at resolving small and simple disputes because the parties must comply with pretrial procedures such as the exchange of documents and other evidence, and because there are significant backlogs before a case can be heard by a court. As I've explained, either Consumer Affairs Victoria or VCAT will be the most appropriate dispute resolution body for small and simple disputes. The exception is where neither Consumer Affairs Victoria nor VCAT have jurisdiction over the dispute, for example, as in the case of general negligence and defamation claims. In that case, the only choice that the parties have is to use the courts. Where a dispute is large and complex, I've already explained why Consumer Affairs Victoria will not be an appropriate body to deal with that dispute. However, both VCAT and the courts can resolve large and complex disputes. So the question is, when will the courts be more appropriate than VCAT in resolving large and complex disputes? The courts and VCAT are much of a muchness for large and complex disputes in terms of cost, speed, and their power to make a binding decision. Both VCAT and the courts charge application or filing fees and daily hearing fees, and the parties will often use lawyers in a large and complex dispute because lawyers are experts at presenting large and complex cases, and because the parties will want to ensure that their case is presented in the best possible way, as VCAT and the courts will decide the dispute by making a decision that's binding on the parties. Both VCAT and the courts also suffer from backlogs in dealing with large and complex cases, and both VCAT and the courts can make a binding decision that resolves the dispute, which, as we've said, is desirable because the parties are much less likely to be able to agree a resolution to a large and complex dispute. So far then, there's little to choose from between VCAT and the courts where the dispute is large and complex. However, as set out in this third golden rule, the courts will be more appropriate than VCAT in resolving large and complex disputes in two circumstances. The first circumstance is where the parties prefer the more formal structure of court proceedings, including the application of the rules of evidence and procedure. Court procedures are very detailed and provide a clear framework for dealing with even the largest and most complex cases. The second circumstance is where the parties want a judge to decide the dispute because the dispute involves complicated legal issues and judges are legal experts, or because the dispute is lengthy and judges are experts at conducting lengthy trials. In contrast, as I've said when explaining the second golden rule, if the parties want a subject matter expert, then VCAT will be a more appropriate dispute resolution body than the courts. There are two other advantages that the courts have over VCAT. First, appeals from a VCAT decision are very limited. A party who is dissatisfied with the VCAT decision can only appeal that decision on a point of law. As you know from the previous video on VCAT, such an appeal must be heard in the Supreme Court. However, a party might prefer to have a court determine the dispute because if the party is dissatisfied with the court's decision, there are often a number of grounds on which the decision can be appealed, including a point of law, a question of fact, or the amount of damages. Second, the doctrine of precedent applies to the courts but not to VCAT because VCAT is not a court. The advantage of having the doctrine of precedent apply is that the doctrine of precedent ensures consistency and predictability, which means that the parties are able to form a view about what the court is likely to decide and therefore whether it is worth taking the dispute to court. Well, that brings us to the end of this video. As a result of watching and taking notes on this video, you should now be able to do two things. First, you should be able to describe the purposes of the Victorian Civil and Administrative Tribunal in resolving civil disputes. And second, you should be able to discuss the appropriateness of the Victorian Civil and Administrative Tribunal in resolving civil disputes. As I've said, you will be undertaking a number of learning activities in class which will also help you to achieve these learning intentions. Don't forget to read the pages from the textbook referred to on the first slide. And if you find any additional information from that reading that you think is useful, then supplement your Cornell notes with that additional information. Thank you for your attention.